Okay.
And they'll do check for prints and DNA, and this is a map. So our main entrance is here, go through that parking
Has
lot,
he
down the street,
sat 48
in
hours?
the next little parking lot, and they've got a
No.
buzzer at that door.
Okay, so he's gonna wanna do that. Before I proceed, I just want to make sure that you do understand that once I take your plea, and if you're found guilty, you have to report immediately to jail to sit 48 hours. Is today a good day to do that?
Yes, I already talked to Tessa about that.
Excellent, okay.
She had on the schedule. Yeah, she had on the schedule for the release on
Excellent.
Friday.
We will go on the record in the matter 25 CT 51, State of Wisconsin versus Matthew Swenson. The state appears through District Attorney Kevin Schmidt in person. Mr. Swenson appears in person with his counsel, Bruce Anderson. We're set here today in this matter for a plea and sentencing hearing. Mr. Anderson, can you please state the agreement on the record?
Actually, I didn't bring my computer in today.
On the plea questionnaire, it just says to be determined.
That's because I didn't have my computer with me.
Okay, so would it be the IDIP guidelines for, are you sticking at the BAC 0.323, or is it amended as a part of the agreement to a lower amount?
Well, that's where Tessa spoke with Mr. Swenson, and I realize it's not her call. But she had quoted to Mr. Swenson
Oh, to Mr. Swenson.
a 45-day jail term, which falls in the guidelines for 0.15 through 0.169.
0.199, actually.
Pardon me?
It's 0.15 to 0.199.
I must have picked up an old guidelines then.
Could have the old guidelines. I'm looking at the new ones.
Oh, I got this out of the bin outside.
They might, I don't know, maybe I have the old one. I don't think so. Nope,
I don't
because
have one.
my old one says old, but can you hand me, oh, yeah, can you hand me one from over there? Because I'm out. But we're out here.
Where are you?
Someone took my last one. So
This is, I have mine laminated, so I can have it, and this is what I have old and I have new. Oh, wait, from September 2025? No, this is the new one. Yeah. Can I see that one, please? Thank you. We're off the record, sorry. Yeah, these look very old. Oh, no, this says 0.99199. You said 0.169.
there's a newer one.
That's the last one I have. Let me see that.
There's a May 24 one that's distributing too.
Oh, here's the most recent one I have saved.
Yeah, I don't have any up here and I don't have that. 0.19, so,
Sure. In the 0.15 to 0.169, and then another one right after that.
that's what yours is saying. Must have redid it and I don't have the new one, so I'm gonna have to get a new one. That's fine. I have this now, so that looks like that. Just looks weird with the printing. Yeah, why do I have that one? Yeah, I don't, that's the only one I have. It's the very old one, because we have to go, sometimes when they get old, you have to go back to the old dates sometimes and things. Yep, I have that now. All right, I'll just have Tessa make me a new one, laminated new one. All right, back on the record, same appearances as previously noted. All right, so it's a 0.15 to 0.169, and is that the agreement, Mr. Schmidt?
No, I did it at the IDIP guideline. I don't know why Tessa said something different.
So, Mr. Anderson, do you want to speak with Mr. Schmidt
Well,
briefly off the record? Because I know Tessa doesn't have authority. She's not a lawyer. She just does the things.
Right.
But coming in here and then having to enter a plea and be sentenced, and hearing that it could be a different sentence, I don't want to have any issues. She can't, off the record. Can you get me a laminated new one? Because I'm guessing Tess is not here anymore. That's probably why she didn't give me a laminated new one, because she hasn't been here for a year. Or more. In here.
Ask Kathy or
Yeah.
Tim.
I think that's what she, yeah, I think that's what she did. is she
Yeah.
was there. But
I don't know,
maybe
maybe
that's
she
why I
just
don't
missaid
have
it,
any
but
laminated ones, because she didn't want to do it. Give it to her. So if you could
Give you the 55, it's your discretion. So I think we just
Or May
basically
of
argue it.
2025.
May of 2024, I have a, this is the one that I have, the last one that I was provided that said, yeah.
That's very old. Very old. That's like, ooh.
I think the reason it was revised in May of 24 is that's when the district guidelines changed too.
Yeah, that's what I just was
Yeah,
looking.
you're out, I'm out. I think Mr. Schmidt is out. I think we need more brochures too.
Yep.
All right. Mr. Anderson, thank you for bringing that to my attention. It's been a little bit harder with communication because Tess has been at home working all the time. And so usually she's the one that gives me all those things. So back on the record, same appearances as previously noted. Mr. Anderson, were you able to speak with Mr. Swenson?
I have, he understands that any time is going to be at the court's discretion, as well as any other portion of the penalty. And he is prepared to go forward today, knowing that.
All right, I have a question before we even proceed with plea and sentencing. If the court orders a fine of, let's just say, $1,911 plus a $10 blood draw, would you be able to pay that all?
Yes.
Okay,
Right away.
all right.
Yes. I take cards, right.
And could be 75 hours or 100, depending, of community service. How do you intend to take care of that? Are you going to do community service, or do you want to convert it to additional jail days? And that would be,
I spoke with, oh, want to
Go
go?
ahead. No, go
Okay.
ahead.
you go ahead.
Spoke with Teth about that. Obviously, I did the 8 hours I had to do for the IDIP program. Obviously,
That doesn't count for the 75.
No, okay.
or 100.
yep, all right. And we talked about that, and being the president, I'm president of our Snowmobile Club and do countless hours of that kind of community service all the time, year round. And I know it doesn't go towards this, but I mean, I do quite a bit of it. And like I run the meat raffles for the Webster High School athletics program, help do that once a month for them. So I mean, I'm always doing community stuff for the thing, is what I talked about with Tessa.
All right, so
Oh, I'm sorry.
you do a lot of community service in other ways, and it could be for clubs or by yourself. And that could come into an argument with the court as it relates to all of the sentencing. And it could be accepted perhaps, but with this, if you do convert it, it would be 10 extra days on the monitor. So an extra $250.
Mr. Swenson has indicated he wants to pay the $250.
Okay, all right. Okay, so now
'Cause I
that we
paid-
have that settled and everything's going, we have an OWI 3rd here. And I have your plea questionnaire and waiver of rights form along with the addendum to the plea. Did your attorney go over this document with you thoroughly?
Yes,
And he went over it essentially, basically word for word?
yes,
And did you sign this document?
yes,
You're pleading guilty to an OWI 3rd offense. You are 47 years old. You have 12 years of schooling. You can read, write, and you understand the English language. You are currently not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours. Is that all correct?
correct.
Did your attorney go over with you what the state would have to prove, as well as the minimums and the maximum possible penalties you face?
Yes,
Do you understand that because there are allegations of committing a crime, you are entitled to constitutional rights?
yes,
You understand that those rights are on the plea questionnaire? And did your attorney thoroughly go over those rights with you?
yes,
Do you need me to go over those rights with you in any more detail?
no,
You fully understand them?
yes,
And do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that as to count one, operating a motor vehicle while under the influence, third offense, that the state would have to prove on or around September 14, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant, and this would be your third countable offense. Do you understand what the state would have to prove?
yes,
Do you understand the minimum possible penalty could be a fine of not less than $600, but no more than $2,000, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
yes,
Do you also understand the court shall order an AODA, OWI assessment and driver safety plan and follow through?
yes,
You also understand that the court shall order your license be revoked for not less than 2 years, but no more than 3 years. Do you understand that?
yes,
Do you also understand that the court must also order an ignition interlock device to be placed on your vehicle during the revocation period?
yes,
Do you understand that there is an agreement that's been reached and it's been recited on the record? But do you understand I don't have to follow that agreement?
yes,
Simply said, I can sentence you to anything that I find to be appropriate under the circumstances, even if it's the maximum possible penalty.
yes,
Do you still wish to proceed and enter a guilty plea?
yes,
Did you go over that criminal complaint with your attorney?
yes,
In particular, did you go over the probable cause section?
yes,
And that's that part that basically says what happened and why you were charged with the crime. You remember that?
yes,
For the most part, are those facts accurate?
yes,
Are you admitting here today you in fact did operate a motor vehicle while under the influence?
yes,
And this, are you admitting here today this would be your third conviction for operating a motor vehicle while under the influence?
yes,
Mr. Anderson, may the court use the probable cause section of the criminal complaint and the statements made by your client to find a factual basis?
Yes, Judge.
Has anyone made any threats or any promises to you for you to plead guilty today?
no,
Are you pleading guilty freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter thoroughly?
yes,
Has he discussed the evidence and discovery with you?
yes,
Has he discussed whether or not you have any legal defenses or a lack of defenses? Like, did he say, oh, it looks here like I think if we argue to the jury, we can do this? and
no,
this is
no,
Okay, so you don't, he talked to you about those?
Yep.
And do you understand, well, he talked to you about any defenses or lack of defenses. Are you satisfied with his services?
yes,
You have any questions for the court or your attorney before I proceed?
no,
Then as to count one, operating a motor vehicle while under the influence, third offense, how do you wish to plead?
guilty,
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. The court will find a factual basis to accept your plea of guilt and that you understand the constitutional rights you're giving up here today. The judgment of conviction will be entered. Argument and sentencing recommendation, Mr. Schmidt.
Judge, we have these IDIP guidelines because it incentivizes people to do the programming beforehand that we believe makes them safer drivers in the future. It still has a punishment component in that it's very expensive. It results in a revocation of their license of some degree. And because it does have a jail component, even if that jail component for most of it's going to be on electronic monitor, he will still go to jail. He will still have that 48 hours that the legislature demands. But I think especially when we've had these days where we have a court with tons of OAR hearings where we see all the people who didn't do the driver safety plans, we see how beneficial for the community this sort of diversion or post-charging diversion really is. So I ask the court to follow the recommendation and give the defendant the benefit of the IDIP program. Thank you.
Thank you. Mr. Anderson.
Judge, Mr. Swenson got into the IDIP program relatively promptly. He completed it. And as I have no reason to doubt his discussions with Ms. Anderson, and of course, realizing she's not the one who makes the ultimate decisions. Mr. Swenson operates Sweeney's Bar and Grill in rural Webster. As he has said here, he didn't do any more than the required community service that had to be done. However, he is prepared to pay the extra fee for not getting community service. Although, as he's told the court here today, he, as the nature of his business, holds, shall I call them, charity raffles, where the profits from the raffles, if you will, go to, he mentioned the school district. He also made reference to the fact that he is president of the local snowmobile club and volunteers his time year-round for the various things they need to do to keep the trails accessible for when the snow comes, if it comes. But he also would need to make sure that the property owners are up to date with the easement grants that they may have given, or seeking additional easement grants for any that they need to replace. That's an element of community service. He's not asking that that be counted, but I think what he's trying to make a point of is he's an active member of the Webster community, and will continue that regardless of what the court may order here. If he chooses to do some other form of community service, he can work that out with Ms. Anderson after today even. On the night of his arrest, he was arrested in the evening, and he did spend overnight before he got released after midnight. So that doesn't meet the 48-hour requirement, but it is where he would get 2 days of credit. He also had his operating privileges suspended by the Department of Transportation. And that was for a 6-month administrative suspension. So he will get credit for that time. And what I'm recommending, and it's a little bit, it's over minimums. We are requesting that the court impose 45 days of jail. That's only 10 days less than the maximum. He's going to pay his fine in full as soon as we leave court here today. The revocation can be for 24 months. He will get the 6 months credit. What I am hoping the court will fashion would be IID credit, where he won't have to have the ignition interlock device after he may have his regular license back. And the court did say he would have to have the IID during his period of revocation earlier. And I would like the court to consider a 1 year or 18 month.
I don't think I can do that, quite honestly. I'm pulling up the statute right now. I don't think I can do that.
It's interesting. The IID is being ordered for as little as 1 year in many cases.
Not in my court, and I follow the law.
I understand that.
I guess, accept
And
guidelines, but
it may be an issue that I may have to take up with the DOT, because he's gonna get credit for the 6 months administratively. That is state law also. So may end up having to have the IID for the additional 6 months when he's back to his regular license then.
yeah, I'm seeing that there's no provision in the statute that would allow me to reduce the length of an order for an ignition interlock device lower than the mandatory minimum for any reason.
I understand. And certainly you follow the law on that, and it's pretty clear that is what it says. And I don't know if it's just creative judging in other places or not, but
Well, you can do what you can do until the Court of Appeals tells you can't.
right, that's what.
But I really do try to follow the law.
So, anyway, we'd like to see a fine less than the 3175. We'd like the 1911, 45 days, 24 months IID and revocation, and the 75 hours of community service or payment or some combination thereof. 2 days credit plus the 6 months administrative.
All right, thank you. Mr. Swenson, anything you want to add, you want to state here today?
No, I know I screwed up. I've learned from there, and it was like I say, just a bad evening. They're my family, and I'm raising 2 young girls, and it's changed, and we've have erased that night from my life, and I've been doing very well and being a good father and a good husband.
Mr. Swenson, I'm very glad to hear that. I do not want to see you in this court or any other court for a 4th offense, because then it strips your driving forever.
Yes, I know.
Except the caveat of after 10 years, you can try and petition, but it's very hard.
I've learned that talking with my counselor through the Aurora, explaining all that, and she's which I've completed, and that really helped me a lot with talking to her. So
I'm going to tell you, and I know you understand this. I don't understand this personally, but my aunt owns a bar. She still owns it, actually. It's a different life. You are around alcohol 24/7, because let's face it, a bar really is kind of 24/7.
Yeah.
Even though you're closed some of the time. That's a big trigger for people to work and not drink if you have a substance abuse issue. Only you can determine to what extent alcohol controls your life. And if you're going to take control and start controlling your life instead of letting the alcohol do it. And I know I don't have to tell you, but I am going to tell you, because I do tell at least some people when I remember to say, the issue is not your drinking or your drinking in excess. 0.323, OMG, that's high. But I mean, my mom was a nurse, she saw higher, 0.5. So it's crazy that what the body can tolerate and build its tolerance up to. But the issue is not you drinking or you drinking to whatever excess you want to drink. The issue here, and the problem that you have at least 3 times now, is getting in that car and driving. It's your life, you make the choices, but then you have to suffer the ramification of those choices. I hear that you are a good community man, good father. You're trying to run a business. You're trying to be there and help the residents of this county in multiple ways. And I get that, and I understand that. We need more people, younger people of this age, not the 70-year-olds, because that's dying out. We need more younger people to be involved in these types of events, because otherwise they're going to die, and then we're not going to have anybody doing them, such as how the Lions Club and the Lioness Clubs are kind of,
yes,
they're suffering.
and I'm the youngest person in our Snowville club, so I know.
I know, and they suffer, and it's an issue, because I mean, I would love to do some of those programs. I can't, I just don't have the time. But I'm glad that you do. OWIs are very, very serious. I don't think I have to tell you, but I think we had a case where somebody left Sweeney's. I think a couple people did, and a kid got ran over. twice by 2 cars, got hit by 1 car, then got hit by another car. Luckily, that wasn't you who has been in something that you didn't cause an injury or something to somebody else, or you didn't die, because you have 2 little beautiful baby girls that need their father. They need their father to be present with them and sober, and to step away from the bar sometimes,
Yes,
because the bar, it really is your life. I know that. You're doing good things. You did the IDIP program, which is a lot, and you're getting your life together as it relates to the alcohol and that substance abuse issue. I don't think the community is at risk or at harm. You've learned a lot in the program, and hopefully, upon all hopes, you are going to install what you've learned into your life and continue that forever. Again, I don't want to see you get an OWI 4.
Oh.
What the court is going to do is, I mean, I can't guarantee or say that Miss Anderson told you a lower amount of time. And you know, and Mr. Anderson knows that she's not a lawyer.
Yep.
She can't tell you what the sentence is going to be. But that's, if she did do that, then that's an issue for me to talk to her as her superior about that. In looking at all of the facts together and taking into account all of the information that's been provided to this court, what I am going to do is I will sentence you to 45 days in jail plus 10 days. So a total of 55 days. And I'm doing the lower guidelines simply because you are a community member that does a lot for our county and our community. And I believe that, I mean, you're going to sit 55 days anyway. You're just not going to have that community service requirement, but you are doing community service, not every day, but a lot of days. So that's why I am going to do the lower bracket. So it's $1,911 plus a $10 blood draw fee. You're going to pay that today, hopefully. Otherwise, I'm going to say you have 20 days to pay.
okay,
Okay. I'm going to order 24 months of ignition interlock device and 24 months of revocation of your driver's license. I'm going to give you credit for any administrative suspension you've already received. And I'm going to state on the judgment of conviction in my decision here that if the Department of Transportation, the DMV, were to say that because of that credit, you don't need to have the ignition interlock device for a full 24 months. As long as I have proof of that, I'm okay with doing that, but they're the ones who essentially control that aspect. The law tells me I shall order 2 years at minimum. So it's 2 years ignition interlock device, 2 years revocation of driver's license with that credit. I am going to tell you though, I have never denied anyone, not anyone, when they apply for 50% cost for the ignition interlock device. So if you want to do that, you would see Amy, who is our traffic guru, and she can explain that or give you the form. Okay.
okay,
Because to me, I don't care, well, unless you're a millionaire, I guess, but I don't care how much you make. I just want people to get that on, follow the law, do what they need to do, and get over that and be done. I have to order that you sit 48 consecutive hours, and it's an immediate report. You did the IDIP program, so I will give you the option to serve the remaining time on electronic monitor, which does monitor your skin and your sweat. So it'll detect if there's any amount of alcohol in your system.
yeah, that's fine.
Plus, if you don't get gasoline or rubbing alcohol or mouthwash or probably cologne near it, because it will go off and give a false positive. I'm going to tell you right now, I don't listen to people's excuses of false positives. If it alerts that there's that it detected alcohol, you will be told you're immediately revoked and you must go sit the rest of the time in jail No good time, no Huber, all right? Well, on the monitor, 2 days jail credit,
Yes.
and while on the monitor, absolute sobriety, no alcohol,
Yeah, that's fine.
you can go to work, you can go to church, you can go to the grocery store, 1 time a week. Tessa will go over the policies, the procedures, and the limitations there. You can't do, I mean, community service, because you're doing it, that may be something that will be approved. You have to talk to Ms. Anderson, and then she'll send me a request, and I'll decide if that's appropriate. But you can't go to somebody's pool party.
Yes.
You must only throw your own pool party. People can come see you. You can't go to them. Do you understand?
Yes.
Anything else I'm missing besides the last words I have to state on the record as it relates to the monitor, et cetera?
Well, I'm sure he can work this out with Miss Anderson. He's a bartender. He works at his own bar and grill,
That's Huber, that's fine.
but he may get alcohol on him that spills or whatever,
No, that's his
or
problem.
cleaning up a table. So
You just better be
There,
careful.
that's, well, I was gonna ask that question also. I mean,
I mean, and
Doesn't
if you
happen-
want- If you want to tape a bag, like if you have a cast and tape it over there while you're cleaning up, then that's what you gotta do.
okay,
Because if it registers, I understand that you do work in a bar and grill and you do those things. And I do understand alcohol spills, but do you see how I can't?
yes, no, I
can't
understand.
trust that
That's-
That's it.
Yeah.
I've been told so many things, and that's why it's like, nope, it is what it is. You'll
No,
be revoked.
I
okay?
understand.
And then Judge, one more thing about the extra 10 days, that's for the community service. And what does he have to pay for that if he doesn't want the extra 10?
Oh, it would be $250,
Right.
and that would be
'Cause I paid-
paid to Ms. Anderson, and you have to prepay 30 days in advance for
I
the
did.
monitor. Okay?
Yeah, I did that.
It's done. Yep.
Okay, so that would be an extra $250. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. If you fail to pay your fines and fees, the court will enter a civil judgment against you. I will also issue a warrant. You could sit up to 6 months in jail. I need your DNA. You're gonna have to provide that to the jail. They'll get it when they book you in. You have the right to request it be expunged from the system through a written letter to the Department of Justice, not to me, but to the Wisconsin Department of Justice. It's easy to do. If you want to do it, you can Google it or ask Mr. Anderson. He can show you how to do it. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Anderson.
I believe that covers everything, Judge.
All right, immediate report. What you can do is go to the clerk if you're going to pay your stuff, do your thing, talk to your attorney. But then once you're done, immediately go to the jail, get booked in, sit your 48 consecutive, and then you can be hooked up with the monitor, okay?
She just gave you.
Ms. Sangate?
Then jail, like, go at the front and walk all the way around.
Yes.
You come up here, I have your minutes.
Want to take this up too?